Welcome back. I'm Bob Bianchi. I'll be with you at 3 o'clock, and I got Kenney Baden with me, one of my besties here at the Law&Crime Network.
Your New Jersey bestie.
My New Jersey bestie. Boy, we got so much to talk about. It was a compelling interview with Brian, and really a tragic thing there with the MGM and what they're doing, and something tells me that the court of public opinion is going to persuade this course of action to be reversed. But we're also in the throes of the James Colley case, a horrible double murder case. He went down stem to stern on everything just about an hour ago in the verdict. It's a death penalty case. And Linda, before we're going to flip to some testimony here that I think is going to be really interesting in the penalty phase, we had been previously talking about from the minute that the lawyers walk in opening statements on a death penalty case, every single thing they should be doing, the prosecution is not just winning a guilty verdict, but the death penalty sentence, as well as the defense, while they may not be raising a great defense for he didn't do it or a lesser offense, they're looking to spare his life.
Right.
There was some pretty dramatic testimony in this case, but let's talk about something that you had mentioned before that tweaked you a little bit in terms of jury psychology, blaming the victims. Tell us about that.
Right. Here, we know the defense would come in here and say they have to save his life, that he's really not going, he's going to be found guilty. If I'm trying the case, that's my assessment of it, okay? So what you're trying to do then is do everything you can for the penalty phase. Everything you do as an attorney then becomes for the penalty phase. You can't do anything that's going to hurt your client because he's already hurt by his actions. You know he's getting convicted. You know the jury's going to hate him. But then when you come in as an attorney and you start saying things like Amanda Colley had, and I'm paraphrasing, stringing him along, and that's the why as to why he did this, that's going to anger that jury. And if you anger that jury, you don't really have a chance in the penalty phase. So I think lawyering is very important, and I think lawyers have to learn from watching cases like this. The why he did it doesn't really matter in this case because it's not going to be mitigating when you're blaming the victim for the why.
Yeah, I think that there's a sentimentality here, and if I were the defense attorney in this case, what I would be trying to do from the beginning all the way through to the end is to say, listen, he did a horrible thing, completely outside of his character. He was overwhelmed by what was going on. I would be a little softer in saying, you know, things weren't going great in the relationship and trying to explain it without victim shaming the woman. Then they're in court. He's angry. He's frustrated. Then somebody texts him a picture of her new lover where she had found sex toys. He had found sex toys the night before, and there he is mowing the lawn with his shirt off. And look, we're not saying it's excusable. We're not saying it's right. But you know what? This isn't the kind of guy that just went out there and just murdered an innocent random person, spare his life.
Right.
That's the argument.
Right. Well, you try to get in things from his whole history to show there were good things and something little by little changed him, and this changed him, and then he couldn't control his emotions. But here, you didn't do that. All you did was basically attack the victim, and you really can't try a death penalty case like that. Now, I know this is a difficult case. I know the attorneys did their best. I know things happen in a courtroom, but it just goes to show you that even if something happens that you don't expect as an attorney and you don't somehow correct it, it could hurt the client in the end. And I expect this could hurt this client in the end. Right.
Well, the attorney may have to think about that and fall on his sword and do the old, hey, anything I may have said.
And the jury won't care.
Yeah. So, listen, one of the things I think is most compelling in any murder case, and certainly death penalty case, are the facts. And sometimes as a lawyer, you're stuck with those facts, right? And one of the most compelling witnesses in this case was Rachel Hendricks. She was the woman who was stuck in the closet where Ms. Dobbins was also hiding. And if you recall the testimony, it apparently his estranged wife has been shot because she's no longer screaming and yelling. He starts heading towards the closet, screaming out, "Where is he? Where is he?" That is the guy that didn't have the shirt on. Unknowingly, he had already fled the scene when the shots started firing. And there was Ms. Dobbins and Rachel Hendricks hiding in a closet.
Can you imagine?
I mean, honestly, and this is what a good prosecutor is going to paint this picture, heart pounding, not really breathing, believe it or not, right? Because you don't want to have anybody know that you're there. And then when he's at the door, he actually fires a round through the closed closet door, which grazes Miss Hendricks' arm, and then he goes in, passes Miss Hendricks, goes to Ms. Dobbins, and shoots her in the head. Purportedly, the reason reason for that was that he had been blaming Ms. Dobbins for encouraging his estranged wife to move on with her life. So that's a very goal-directed behavior.
Intentional,
premeditated, but we're past that now. And so the folks in the audience know, we're not talking about premeditated murder anymore. That's done. That deal is sealed. We're talking about whether or not aggravating and mitigating
and
factors.
Whether it's heinous, right?
And whether it's a heinous crime. And I think that those facts are going to be really brutal, Linda. Let's listen to the best witness, in my opinion, in this case that drove home the fear that this jury will not forget in the penalty phase, Rachel Hendricks. Hey, welcome back. That was Rachel Hendricks. She was testifying on the James Colley case. He was convicted up and down on all offenses today. And we have a short period of time. We're going to take a break, and we're going to come back on the other end of that break. And me and Linda have been gaming here from what our audience is saying in the chat room. What do we want to talk about? So we're going to start with the basics of death penalty litigation. So a lot of people get confused about all this. So let's start, Linda, with the idea that in order for the government to be able to move forward with a death penalty case, in the beginning of the case, they have to weigh the facts of the case and determine something. That is whether there's aggravating and mitigating factors. Now, people use that term loosely, colloquially. But what they're doing here is very specific things in the law that are called aggravating factors and mitigating factors. And then they have to file with the court and with the defendant to say, hey, listen, we have decided to turn this case into a death penalty case. In other words, the defendant has to be given notice that they're facing the death penalty. And then they go to trial. And if you're convicted of the predicate death penalty offense, which this Mr. Colley was today, it's at that point you move into the sentencing phase. But before we get to that, on the other end of the break, we're going to talk about what actual aggravating and mitigating factors are. What is your, would you think that this was an appropriate case for the prosecutor to bring for the death penalty?
Yes, because you have one of the aggravating factors if the crime is committed during an injunction for spousal abuse. The injunction was that morning, right?
Well, I'm going to go through all the aggravating factors now, but I mean.
But yes, there's so many different aggravating factors. Absolutely. If you believe in the death penalty, this is a case that qualifies.
Right. Now, listen, I've had my ups and downs with regard to whether I'm a fan of death penalty. Actually, I've seen Baltimore Joe's actually talking about this online as well. Sometimes I think it's disparately shown.
Absolutely.
A lot of times the facts are different. Some people get executed, other people don't. And when you're talking about that ultimate punishment, sometimes I've been very concerned about the manner in which the administration of that judge, even states, right? From state to state, county to county within New Jersey, some were more likely to give the death penalty as opposed to others. But with all those things aside, in Florida, it is a death penalty state. They execute often. And we're going to come back on the other end and actually speak about those aggravating and mitigating factors, folks, after the break. And you got to stay here and listen to my girl, Linda, talk about this. Welcome back. I'm with Linda Kenney Baden. And if you are not with the Law and Crime app, Linda, or if you are not online right now, chatting in the chat room, then you are missing a lot of great commentary from our viewers.
And we're missing their input,
Not me. I'm watching all the time.
Yeah, but people that aren't there.
I'm watching. And by the way, guys, they had to actually reposition the cameras because my Italianness keeps coming out, and I keep, because we speak with our hands as well, so I keep going into Linda's shot. So they actually had to bring it back, Linda. But no, listen, seriously, we're watching your comments, and they're really, really good. So our producers have been kind enough to let us run a little bit with this. The previous comment we talked about is the death penalty, whether you're for it or against it. Now, I've tried death penalty cases as a prosecutor.
Me too.
And I think I became less inclined to be in favor of it, not for religious reasons or other reasons that people give, but from the justice piece to it. How good is the lawyer? Sometimes lawyering wins cases, but some people are bringing out some really good points. Like Kit Kat 2409 says, and this is actually something that's argued in a lot of death penalty cases, I'd rather see them rot in jail. And they actually do use that. It's more of a penalty to rot in jail, if you will, than it is to be executed.
And also, remember, there's been so many people in the Innocence Projects all over the United States have showed us who were like 2 days or 5 days from getting executed. Turns out they were actually innocent. Now, I'm not saying that's this case, but so it's unequally applied. When it came back in 1972, it's supposed to be for the worst of the worst of the worst. And I hate to say this because every murder is terrible, every victim is terrible, but the death penalty tries to make crimes different, tries to make victims different, quite frankly. And that's the whole point of it, of these statutes, so that you only execute the worst of the worst.
Yeah, well, actually, it's funny you should use that. I'll bounce off you because Y Guy 54904 said, Well, I get what you're saying, but if there's proof positive, then I don't, essentially
Right.
they're saying they don't have a problem with it. And the problem with that, I get that sentiment certainly, and that's why I actually went forward with my death penalty cases, because I believed without any question, proof positive that these people did it. But nevertheless, you can't write a law that says, hey, if you really, really, really are guilty, you can get the death penalty,
Right.
as opposed to really, really maybe guilty.
Or in another state, he may not be death penalty. A prosecutor could decide based on their discretion that he doesn't get the death penalty. He's
Right.
not, or in a state that doesn't have death penalty to begin with. So that's where the unfairness comes in.
You bring up a huge point here. Now, when I became the county prosecutor, I found out that in my county, every single murder case that occurred in my county, they filed for the death penalty. Every single one. Where in other jurisdictions, crimes that were far less in the homicide range, a death penalty case, they did not. And so it just brings, you could literally walk over a county line from one place to the next. And if you committed the same crime, one would be a death penalty case, one wouldn't. It was just too much randomness to it, Linda.
And in the past, the studies have shown in the past, I don't know about right now, but that people who were African American or minority who were accused of committing a crime against somebody who was Caucasian would get the death penalty more than somebody in a like position with a Caucasian on Caucasian crime.
I'm going to tell you something you're going to find fascinating. I'm going to give you guys an inside scoop about a death penalty case I had at one point. After 2 years of trying the case, Linda, 2 years of trial, the victim's family and we all decided, look, let's work this case out to a life sentence, and we wanted to take it out of the death penalty. And we were not allowed to take it out of the death penalty because everybody agreed to it. Why? Because the bean counters at a higher level than us said, this is a white defendant, and it would ruin our proportionality arguments. That's the argument you just raised. That more minorities get executed.
I didn't use it, but it's called proportionality.
Right,
yes.
that more minorities get proportionately more of the death
Right.
penalty sentences than white people. And I remember sitting there in shock saying, I mean, the fact that you're even considering a person's, you're doing the reverse of that.
Yeah,
you're considering the fact he's a white guy.
And remember that terrible case in Connecticut where the doctor and his family were brutalized, and most of the family was murdered, and they were raped, they were set on fire, and Connecticut did away with the death penalty. I mean, when you saw that case, if there was a death penalty, that's kind of the case, the worst that you say, this one qualifies. But the problem then in the state over, it doesn't qualify. So that's where you are.
Yeah, it is very disparate. Just real quick, Laura Lux, I think Lorellux said false convictions, wrongfully accused people. You've seen that happen before. People who later turn out to be not guilty. Boy, it's a pretty draconian penalty when you find out somebody was executed that in fact was innocent. But listen, we got so much to talk about here, folks. I'm sorry to run through it so quick. Linda Kenney Baden is going to be with me on the other end, but let's go back to what's going to be the most compelling piece of the prosecutor's argument, in my opinion, in the death penalty phase of this case, which will be upcoming in a few days, of the James Colley case, and that is the continued testimony of Rachel Hendricks. Wow, I guess anybody could look at that and say, can you imagine if that were me or that were my sister or my wife or my loved one? It's really compelling testimony. And Linda, we're talking about now the penalty phase, which is completely different than the guilt phase.
Yep.
But remember, it's the same jury. And the jury has already heard and found him guilty of the premeditated murders and all the way up and down the line very quickly. Okay, that gets you to the penalty phase. But in order to win at the penalty phase, now we're going to get into those things called aggravating and mitigating factors. And because I know Linda Kenney Baden is the real deal, I told her she could take the aggravating factors and I'll take the mitigating factors in Florida. And we're going to explain, because the prosecution has to prove at least one aggravating factor beyond a reasonable doubt to all of the jurors in order for there ever to be a death penalty. And then you get into the mitigating factors, and then they weigh those and make the decision. Linda, what aggravating factors are here?
Okay, so there's a lot of aggravating factors under the statute, but there's 4 that definitely seem to apply here. One, and we started talking about it, that the crime was committed while there was an injunction for spousal abuse. And that injunction was granted just that morning that he committed this rampage against these people. So I think check that for the prosecution, right? And and then was committed in a cold, calculated, premeditated matter without moral or legal justification. Well, let's check that, because he was convicted of first-degree murder, premeditated, right? Check that for the prosecution. And by the way, he's going to have to do for 2 victims on that. And when you shoot somebody in the head and you're going to them in the closet and you shoot them in the head, I think that's a little premeditated. And when you shoot your wife 9 times, that to me is premeditated. Next one, heinous, atrocious, or cruel. Well, again, I think that this qualifies. Again, you come up to somebody, imagine the terror of the person being shot, the gun is attacked, you know, the gunshots, and then in the head. I mean, that's atrocious, that's cruel. It's almost like it's torture. And then the wife with 9 shots. I mean, I wasn't here for the medical examiner's testimony. The viewers will know better than I. But many people who are shot the first time don't die immediately. They breathe in their blood. It takes time to die. So depending on how that happens, that could qualify her death as heinous, atrocious, or cruel. So those are the 4 I see. And remember, Bob, these type of aggravating factors have been litigated for over 36 years since the Furman case was decided. And so they're pretty set in stone as being actual legally qualified aggravating factors.
Right, and you know, Linda brings up a point that a lot of people don't know. You could read off the sheet the aggravating factors, but there's probably been hundreds of cases that actually delve in deeper as to what applies and what doesn't apply. But those are the aggravating factors pursuant to the statute in Florida, and they're very similar to the death penalty aggravating factors
in New Jersey and
other places when Jersey had it before they abolished it.
Jersey abolished it.
2007, actually, when I came into office. So now is the mitigating factors thing. Now remember, the defendant doesn't have to prove anything in a case, but like Linda indicated, it is very likely that 12 jurors are going to come up at least with 1 aggravating factor, if not all of the aggravating factors Linda referred to. So what are the mitigating factors? Because this is where the uneven playing field comes into play, in my opinion. When I was a prosecutor, I didn't like it. Here's why. You just listed those aggravating factors. Here are the mitigating factors that we see at play. That the defendant has no significant history of criminal history. And I think that they're going to find that in this particular case. That the person was acting under duress. There's going to be an argument there. That's where I think the defense was going, although we agree he may have victim blamed a little too hard, you know, at that piece. But it's going to be in the case. The capacity to conform your conduct, you know, if you're really agitated, upset, under duress, conform your conduct to the law. I don't think he's going to get that mitigating factor, but it's in play. In other words, the jurors aren't going to come back with that. And again,
but it's in play.
Only 1 juror's got to come back with the mitigating factor.
But they should know that you only need 1 juror to find that the aggravating factors are not, you know, do not outweigh the mitigating factors.
Linda, this is why it's unfair. And as a prosecutor, I was up at night because I'm like, wait, why do I got to prove an aggravating factor to 12 people beyond a reasonable doubt?
Because it's the ultimate penalty.
It's because it is the ultimate penalty, and the playing field is very uneven. And here's the most uneven part of that playing field. Unlike the state's aggravating factors have to be proved, one of the ones for the defense in every state is and any other factor that may mitigate against that. And that's where they bring in previous social history, people who are sick, his kids,
brain damage,
everything comes in the kitchen sink.
That's exactly right. So and they're going to argue that his kids are better off with 1 parent alive, even though he killed the other parent. Those 6 and 4-year-old, that 6 and 4-year-old are better off keeping him alive so that the kids have a father. You watch.
Yeah, definitely. And listen, we're going to go back and we're going to play some more clips here of this case. But when we come onto the other end, I want to talk to Linda strategically about what we have seen being introduced by expert witnesses in a penalty case, because I have been surprised recently that these penalty phases go very, very quickly, and there's not a lot of expert testimony, at least expert testimony that I've seen. When we talked to one of our people that in the chat room, KitKat 2409, for example, it says rotten jail. There's a thing called an aging out expert that talks about how hard it is to live your life expectancy, you know, as a person who is a murderer in jail. And it would be interesting to see whether or not we're going to get that.
A lot to talk about.
Yeah, I know we got so much to talk about. So listen, folks, we're going to go to some testimony here with regard to some weirdness about the gun and the seizure of evidence in this case, and we'll talk to you on the other end of that with Linda Kenney Baden. Okay, welcome back. The Law&Crime Network. Linda, we got some interesting comments here from some of our people online, BB314, about the Ambien as a mitigating factor, which it clearly could be, but I'm curious if they're going to go into this, because I think the jury would be insulted by this defense.
Yeah, they may go into it. They may say he's an addict, that it controls your actions. I mean, they're going to try everything on it. And look, when you're in a death penalty phase, you have to kind of throw everything out there, because or else, when it's appealed, that will be one of the things that they could say that the defense attorneys missed, even if judgment-wise you wouldn't want to put it in.
Yeah, I think that a defense lawyer has to be very, very careful in the penalty phase, because your client is looking at death, to present anything that the jury could sit there and say, that's a bunch of nonsense.
That's right.
Especially when you have a case with so much goal-directed behavior.
That's right, and that's why you start, when you're a defense attorney in these cases, from childhood. You go interview their class teachers, college, anything. They've taken people, they work with you, interview everybody. You get brain scans if you can, you get medical records, you see if there's anything you could advance to try to mitigate why and what he did. We're
going to talk about how to construct a death penalty case from a prosecutor and defense point of view at the end of the break that we're going to have coming up here. I'm with Linda Kenney Baden. Stay tuned. Welcome back to the Law&Crime Network. I'm here with Linda Kenney Baden. We're breaking down the James Colley case. He was convicted today of all offenses, is moving into the death penalty phase of his case. I'm with a pro here talking about death penalty litigation, aggravating, mitigating factors. And we're going to get back to all that with you folks. It's talk about how defense and prosecution actually go about introducing witnesses to help them out in the penalty phase. I think it's fascinating, and I got a real pro with me. But we're going to go back to Rhonda Colley Boatwright. And part of what we were talking about is bringing family members on during the course of the case. So it kind of humanizes them. It kind of, for lack of a better expression, Linda, we used to say, shows that they're not an animal. That's right.
You're setting the stage so that the jury knows when he gets to the penalty phase that he has a family, that he has a nice sister, he took advantage of her, but that he has a family. You know, in New Jersey, there was a famous case where a prosecutor said, well, even Jesse James has a mother. You can't say that as a prosecutor, but the point is that you're trying to show that they have a family.
Right. Jesse James has a mother.
It was considered bad for a prosecutor to do.
Only my Jersey girl can bring that out. There, my hands go flying into her shot again.
It's okay.
All right, let's go to that.
My hands will fly into your shot, okay?
Let's go to the clip, and we'll get you on the other end. Welcome back to the Law&Crime Network. I'm here with Linda Kenney Baden. You're listening to the James Colley case, some previous testimony. He was convicted today of all offenses. He is going into the capital murder phase, and we're going to continue with some of that testimony. But Linda, we were on some hot topics before, and I don't want to lose steam on the energy of what this case is all about. And it's about
what the viewers want to talk about,
you're going to be executed by the state or you're not, and that's where we're headed. And we've had some really great commentary with people. Actually, BB314 is kind of joking around about side effects of Ambien could be shooting your wife 9 times. But you know what? All kidding aside with that comment, and obviously it's not a funny case.
No, it's not.
I actually was prescribed the medication one time, and I am not making this up. I read it to my wife. She thinks I'm a freak. I said, it says here, a side effect is it may cause murder.
On Ambien?
No. On a different drug. I have never seen something that actually said you would commit a crime. I've seen it may cause drowsiness, may cause suicide, may cause this. But actually, there must have been a statistical population of people who killed while on this medication. So we don't know whether it's going to be used in the as a mitigating factor or not. They didn't use it in the guilt phase, but I think they still may or could, in the penalty phase.
They may say that he had a reaction, that he becomes more aggressive. I don't know. The viewers are going to know more about this than I'm going to know. I just don't know that. I don't think the jury is going to buy it. But, again, as I said, you throw everything out there if you got mitigation. If there's anything, you can't leave anything behind, because then, the case gets overturned. And you have to try these cases, Bob, no matter what your side, when you're a prosecutor, that they don't get overturned, right?
Well,
that's what you want.
I've always said this, and again, these are like rules of the road. There's no sense in winning a case to have it reversed on appeal as a prosecutor. It's not good for the state, it's not good for the family, and it's not good for your case, most importantly. But we're going to go back, Linda, to some of this testimony, and on the other end, we're going to come back with even more insights on death penalty litigation. Welcome back. I got Linda Kenney Baden, my Jersey girl, with me, and we are breaking down the James Colley case, convicted today of all offenses, penalty. I love being on with you because we can really talk some real stuff. We got a couple of minutes real quick. I think one of the people online asked a really good question. Is it fair to exclude jurors who could not impose the death penalty versus those that always could? That's a great question.
Great question.
When you're picking a jury in a death penalty case, it may sound counterintuitive, but the judge tells them that it's a death penalty case and says, if the state proves its case, and if you find the aggravating factors in the guilt phase, the sentencing phase, outweigh the mitigating factors, could you follow the law? Each juror must say they will follow the law. But Baltimore Joe, it's a little different than saying, would you always impose the death penalty? The judge never asks, puts a juror on that says, I would always impose the death penalty. Right, Linda?
That's right. But they could you impose a death penalty if the facts warranted against the law? Sure. But people that say they can't impose the death penalty are automatically off. You're absolutely right. Or they'd have a hard time, and then they try to the defense tries to say, well, you could do it in some cases because they want to keep that juror on because they know they don't like the death penalty. So there's a lot of chess playing in the jury selection.
Yeah, sure. So if a juror, Baltimore Joe were to come up and say, under no circumstances, I don't agree with the law, I don't believe in the death penalty, you're off the death penalty jury. But it's not a mandate that you must find the person guilty. We were also looking at this Ambien and the side effects and whether it be used in the mitigating factors. Would you find real quickly before we go to break?
Quick to react or overreact emotionally. A side effect of Ambien, it's rare, but it can happen. That's going to be used by the defense probably. Irritability, general feeling sad or empty, confusion, depersonalization, such as depersonalization yourself, any victim. So these are actual side effects, whether some are rare, some are more common, but the defense was going to use them, I think.
Okay, great. Listen, we were in the middle of the Rhonda Colley boatwright case, testimony rather. We're going to flip back to that and come back on the other end, and we'll be discussing this more. Thank you. Welcome back to the Law&Crime Network. I'm with my bestie here, Linda Kenney Baden. We're breaking down this case of James Colley, convicted today of all offenses. That was the sister testifying during the guilt phase of the case. And we were talking about how these witnesses in the guilt phase can bleed over into the sentencing phase. And even though some testimony in the sentencing phase would not be relevant for sentencing, the jury still heard this kind of testimony, and obviously you can't ask them to exclude it from their mind. Your thoughts were that she was at least a humanizing witness?
Well, she's supposed to be. I mean, the whole point of putting a family member on in the guilt phase or even having cross-examining, wherever stage it is, whether it's direct or whatever, is that you're kind of humanizing the defendant, that they have a family and the family's nice and you kind of like them. But I am just not sure, Bob. When she says she now has an AR-15 after her brother committed these heinous crimes with her car and these guns, and then she has an AR-15, I'm not sure how much humanizing there is about the family, and I'm not sure how much that helps the defense. I don't think it helps the defense at all. I'd be interested to know what the chat room thinks, quite frankly.
I don't. They're still talking about the mitigating factors here in the terms of the Ambien and the medications, and it
sounds
actually
like
seems,
it proves our point that this is irrelevant.
Yeah, I mean,
right.
It's like before I would ever try a case, I would go anywhere, whether it be a bar, a restaurant, whatever, and talk to people who were not attorneys and bring the case in. And you know what? People would be smart, or the defense would be smart to watch what's going on in this chat room on the Law&Crime Network, because you will see what people that would be sitting in that jury box are thinking, and I think that can inform your decision on how to try a case.
Right. You read newspaper articles, you read the comments, right? You have to read the comments. You have to know what people are saying so that you can address them, because that's going to be your community where you're trying the case.
Yeah, and in the end analysis, I always used to say to people, especially the real smart lawyers, I don't consider myself one of those. Like, you may think you're the smartest guy in the room, but if that jury does not like you, they don't care how brilliant you are. So take it down a notch. Use your common sense. Speak from the heart. Be directed. Tell them why they should buy what it is that you're selling.
You lie to a jury, you are dead as an attorney in that courtroom for your client.
Absolutely. Listen, it's great being on with you here at the Law&Crime Network. We're going to go to a break, and on the other end of that, we're going to come back with some more fascinating testimony and information from you. Welcome back to the Law&Crime Network. Linda, we're in the penalty phase of this case, and, we were talking before about the importance of going online or speaking to people, what the jurors would be here, what resonates with them, what has an impact with them, because people can see things, you know, very differently. And you would agree with that, that's a smart thing to do rather than thinking you know it all when it is you're the side.
Absolutely. What you're doing is creating focus groups, right?
Yeah.
When you try an important case, you have to try to a focus group, which are people that are like the jury you're going to have. But if you go around the community, that's also a focus group, isn't it? Because it's just not you. You can get too involved in the case. You have to see what people are thinking.
Right. Okay. Well, listen, BB314 out there in the chat room. Yes, I do use my hands in the courtroom. It's my secondary form of communication. I don't care what people tell me.
Primary. I think maybe primary.
I can't speak without my hands. In any event, we're going to throw to a clip right now of a Sergeant Eugene Talbert, who is a rebuttal witness for the prosecution. And rebuttal witnesses are tricky things. And we'll listen to it on the other end. We'll come back and talk about it. Welcome back. Law&Crime Network, Dan Abrams production. Get the app if you don't have it. Share with your friends. Let them know what it is that we're doing here, because you got to love having guests like Kenney Baden. Our hands are moving. Eventually, by the time it's done, we'll be holding hands in the front camera by the time it's all done. But love being on with a pro like you, Linda. We're breaking down this case in James Colley. He has gone down in a hot flash. Quick jury verdict back. That's chilling to the defense in the case, and they are moving into the penalty phase. And we've gone over already with our audience the aggravating and mitigating factors. They're very specific things, except the uneven playing field of the mitigating factor for the defense. And I know you love it.
Spoken like a prosecutor.
I know you love it, and any other thing that could be considered mitigating evidence. But you were talking about this before. This could lead to a lot of data and information. What have you seen in terms of that kind of data that you get and the experts used to prove that one mitigating factor?
Well, a lot of it goes to, like, say, child abuse. You see a lot of people in these cases that it will come out that they were sexually abused, they were molested. Happened to a lot of cases I know that in my office when I was a prosecutor. Brain disorders. When they were born, they came out of the womb, they were crushed a little bit, there was some kind of brain lesion. That shows up on some type of MRI. Or CT scan or whatever. So that's the kind of things you look at outside the norm of, you know, he was flogged or beaten in public. You don't find that. You find these little tiny things that may affect the behavior of the person. Yeah,
and a lot of family social history, a lot of experts. We're going to talk about that. We're going to take a break. And on the other end of that break, I'd like to talk about how I've seen some defense attorneys put some pretty good mitigation information together in a death penalty case that actually got me nervous in my cases. And we'll talk about that with Kenney Baden at the end of this break. Welcome back to Law&Crime Network. I'm here with Kenney Baden. We're talking the Colley case. We're in the penalty phase. Let's get right to it. We don't need to be giving our audience knows this case. They know the circumstances. Right. They know that this guy is facing death. And we were talking about the construction of a penalty phase, aggravating factors, mitigating factors. I want to talk a little bit about what I've seen as a prosecutor, the defense do really well. That when you know as a prosecutor you're sitting there in a really heinous case, really horrible murder, and the defense is putting witnesses on it, getting you nervous, right? Well, you know that they're doing the job. And Linda, we talked earlier before offset about the idea that these cases in the penalty phase seem to go very quick. But some of the things I've seen, for example, are, and you were mentioning some of the things before, are social history, if you will, people, usually psychologists or social workers that go through the whole family social history, alcoholism, abuse, not just to the defendant, but that's allowed to be introduced as a mitigating factor to the judge's discretion. And where in a murder case in a penalty phase do you see a judge limit mitigating information?
It doesn't happen, because that's when the case gets reversed.
That's where it gets reversed.
They let everything in. And usually what you find these death penalty cases is the aggravating factors. It's so bad because you're picking the worst of the worst, right? In this case, that no matter what mitigating factors are, the aggravating factors tend to outweigh the mitigating. Yeah,
but you know, I find it interesting, at least, and we talked about this before, about the disparity. In places like Florida and Texas and other places, I mean, no disrespect for that, you seem to get a lot more penalty convictions and and ones that are sustained through the process and actual
I agree with you.
execution.
Right.
In New Jersey, when they reinstituted the death penalty before they then abolished it again in 2007 or 8, we had a number of death penalty convictions, not as many, but nobody was executed. In fact, we had one who actually asked to be executed. Stop the appeals. I want to be killed. And they wouldn't even execute that guy.
That's right.
So
you cannot, as a defendant, stop your appeal. You have to have an appeal in the death penalty case.
Yeah, but that had gone on for 25 years or 25 years at that point in time, I believe. It was a significant period of time. But one of the reasons I bring that out is that, you know, it's one thing when the jurors say that they could impose the death penalty, but my experience in sitting there is after they see the defendant all the time and all these witnesses come on, it's another thing when the judge reads the instruction. It says you individually have to believe the death penalty is appropriate.
Yeah.
Not only all 12 of you,
Yep.
but you individually. People have a different point of view at that point.
You know, Bob, I had a juror on a death penalty case in the penalty phase who actually wet her pants. And we knew because when she got up from to go into the jury room, the seat was wet. They had to clean it. That's how traumatic it is for these jurors. This is not an easy thing, no matter how difficult the case is, no matter what trauma the victims are. It is a terrible thing when you're a juror in a death penalty case. You're not trained. You don't wake up in the morning and say, oh, I'm trained, I want to be a death penalty juror. That doesn't happen. It's just terrible.
Okay. So in the James Colley case, we also had Christine Kerrigan was a crime scene detective. She actually provided some interesting testimony. I think it's going to lead to mitigation in this case. We'll explain what I mean by that on the other end. Okay, Law&Crime Network, Dan Evans production. If you don't have the app, get it. If you haven't told your family and friends about the website and going online and watching these trial live and actually helping with regard to the chat room, always love your commentary. You got to let people know. We want to keep on bringing you these trials, gavel to gavel coverage, and we want to keep on bringing you guests like my Jersey girl, Kenney Baden. And we've got a couple of minutes, Linda, here.
Yeah.
We're talking about how you put together a successful defense strategy in the face of some pretty compelling and damning testimony that came out against this individual. And before we went to that clip, I specifically wanted to go there because I found, and again, I try to squeeze everything I can as a defense lawyer out for my client. Mm-hmm. And one of the things I would suggest is this emotional upheaval, these circumstances that are going on with the guy with the shirt off and mowing the lawn and the sex toys found the day before, without victim shaming or victim blaming. I think I saw something in those photographs. You popped out with it while you were watching it. I didn't key you into it. What did you see, and how do you think it could fit into a mitigating factor of any other thing that tends to justify or excuse the crime?
Okay, so if I'm a defense attorney on this case, I'm looking at that long shot, and the bedroom looked very neat. I said to you, boy, that bedroom looks very neat. And you said something like, just you wait, and it wasn't the Hamilton song. And then we get in, we see this kind of like thing strewn around. We see the gun holster next to the kids' toys, and the box open, and all the ammunition. So if we go back, Bob, to what I read before, which on the Ambien, quick to react or overreact emotionally, right? I would try to tie that into the fact, look at this scene. This is anger. This is not organized. This is disorganized. He was quick to react. He just, boom, he didn't care. The kids' toys, the guns and everything. And then he went out and he did the shooting. It's not, you know, I don't say it's going to overcome, but it's what you have to deal with and work with.
And again, we talked about before, using law and folks and trial work is common sense. My dad told me that when I first tried my first case.
That was great.
He was my dad's awesome, still around, gives great advice. But he said you were a great lawyer going to be a great lawyer when you were 5, 6 years old. That has nothing to law school and all that was just a means to an end. But in the end, it's about who you are and using your common sense and understanding people and human nature. And Linda's bringing up that point, fitting it into this Ambien position here, this Ambien situation. But as a prosecutor, I'll flip the script. I have to think about what the defense is going to do, which is the argument you made. But on the other end of that, I'm going to say, you know what, folks, to the jury, that would have been great if he had just gone in and pumped 9 rounds into his wife, but he didn't. He went into the closet and shot the other woman, went past her, and then went and killed Ms. Dobbins. And why? Because he perceived her as the reason as why his wife was, quote unquote, stepping out with the man with the shirt off, mowing the lawn. And that, to me, would eradicate that.
In my opinion, that's why this is not going to work, quite frankly, is because it's not just the wife, it's, you know, he blamed everybody. And remember, he's got kids. Let's remember, the real victim here, the wife is dead. There's nothing going to bring her back, but those 2 children, they're growing up with this.
Right, great point. Hey, listen, you're at the Law&Crime Network. We're doing some great analysis. I hope you like it. On the other end of the break, we're going to come back and we're going to do a little bit more on this fascinating case. Welcome back. I'm Bob Bianchi of the Law&Crime Network. I shouldn't have to look down to see my name. That's just like a natural tendency. I want people to think like he had to look down to see what his name was.
That's because you're always looking at notes when you talk to a jury, right? When you give us those, you go look down.
Actually, in front of a jury, I never look down at notes.
They're
only
notes. Right. They're only crutches. You know that.
You have it there as like a case.
Yeah.
Only, I think, once in a murder case, I actually forgot the day that the murder took place. It was probably the only time I could think of in all the years I've tried cases that I had to look back and say, I'm sorry, folks, I forgot the date. And if the audience is really good, and someday, Linda, you're really good, I'll tell you when I have my zipper open in the middle of an opening statement in a murder case. It always doesn't go like it does on TV.
Oh, only for Bob Bianchi. You know this, everybody.
You know what? But the jury loved it, and sometimes you just got to own it. When your zipper's open, it's open. You got to let them know. So listen, this case is really amazing. You were making some really incredible insights when we were offline, talking about mitigating factors. And maybe one of the best things the defendant can do isn't to make the defense attorney can do is not make the defendant look really sympathetic, but to talk about family and the effects of the family. Now, Linda, you looked up something that was, again, on the Law&Crime Network.
Right.
If you guys have not been on this website, it is my go-to on any legal issue that happens. The people, it's not just us here. There's a whole team of people out there that are excellent writers and researchers and great producers. And I mean this in all sincerity. When there's a legal issue and it's complex,
right.
I go to the Law&Crime Network to see if somebody did an article on it. What'd you find?
Well, I saw, and you see, I keep the app with me open all the time, so I always go to it. Yeah. Colley turned to his family after the guilty verdicts and said, quote, I love you all very much. So playing off that, right, you want the family's a whole mitigating factor in this, right? The kids, bring the psychiatrist on if it's true. The kids will be better off if he's in jail for his whole life, but they have a father. Maybe those kids still talk to him. Maybe they still love him. Maybe they hate him. I don't know personally, you know. But you have to deal with the kids, and maybe you have to bring the kids on. You know, it's a risk, but you're trying. If as a defense attorney, you're trying to save his life, no matter what he did.
Well, yeah, and I guess you would turn that into that general mitigating factor that I hate with a great passion, which is any other evidence that tends to justify or excuse or not give the death penalty. But no, it would be a fair point, and you would position it that he has a right to be a father to them, and they have a right to have a father. One death penalty case I had, I
do the latter. I wouldn't say, because then the prosecution says, like you, oh well, if he should have thought about that before he killed their mother. But I'd say the kids have a right to have their father. This is the mitigating factor.
Yeah, right. So, listen, these are great points, and I think we can develop this a little bit more, but we're going to listen to part of the prosecution's closing statement here, I think in an area that is going to be very impactful on the jury in the penalty phase of this case. And let's go back to that family dynamic afterwards and see, is that the kind of thing that can kind of overcome some of the hatefulness and vitriol that existed between these two prior to the murder? All right, well, you know, myself and Linda Kenney Baden here have been debating back and forth as we're watching the prosecutor's closing statement in the Colley case. We did a lot of talking about some really nuanced trial law today, and again, the prosecutor's job is to get that death penalty conviction. That's what they're looking for, and the defense is to spare his life. We were literally, before we saw that clip, talking about the kids, and a lot of our watchers on the Law&Crime Network chat room, thank you for being there, are debating this thing back and forth about the kids. And I was bringing up the point in my mind, I would say don't deprive the kids of the father, or, you know, vice versa, because in every homicide case of this nature, where there's domestic violence, the kids lose both parents.
That's right. The kids are the victims. Sad. The kids are the true victims in all this.
And so you want to bring that victimization out. But when we were looking at the prosecutor's closing, I first of all felt the PowerPoint was way too, I don't mean to be overcritical, but the PowerPoint was way too...
No, we're not criticizing Bob. We're discussing nuance and trial work, right?
Nuanced trial work. That's what the folks here want. It was very busy, but I thought she laid out a really nice timeline for what I think the defense is going to argue is mitigation as to why not to kill him. Do you feel the same way?
Yeah, I thought that the defense could creep in there about what was happening and how this was seething, and his emotions took over, and it kept taking over for 24 hours, and it just was a train that was running off the tracks, right? I have to use my hands because I have to be you, Bob. Okay? So yeah, I would use that, absolutely.
Yeah, you know, again, just because you can bring out those facts, and you did, and you need to do that, I wouldn't have been emphasizing them in such a PowerPoint presentation. It's ticking off all the reasons why this guy had basically lost his mind. When you have a slam dunk premeditated murder case anyway, it's just a little nuance, just a little thing in my head. Not that it's going to win the day necessarily, but I just wouldn't have tactically done it that way. Guys, listen, another great witness was, you got to love Lamar Dubberly. He was the guy without the shirt mowing the lawn that may have precipitated him actually coming over there and saying, where is he, where is he? His estranged wife's now lover at the time, and he actually escaped. Chivalry is not dead. When the bullets flew, he ran away. Let's take a look at his testimony. We'll get back to you on the other end. Welcome back, Law&Crime Network. So we're listening to Mr. Dubberly there. He was actually at the crime scene and was one of two people that escaped during this carnage. Another compelling witness, basically telling us what was transpiring live as the shots are being fired and people are being killed. I think he's going to be a compelling witness in the minds of the jurors, certainly in the sentencing phase. And again, he was what is believed to be the intended target, and maybe in addition to his estranged wife that he in fact did kill, because he was asking Linda, where is he, after he saw the picture of him with his shirt off mowing the lawn. That's very premeditated, very calculated, and kind of goes against mitigation, yes?
Yes, absolutely goes against mitigation. And you know, the point I'd like to make about this victim, the boyfriend of the wife, is that he's going to have survivor's guilt all the way through, Bob. I mean, because he knows that it was him, that he was after him. He saw the sex toys, you know, and he went to the house. It just, you know, the whole thing is terrible when you talk about the victims.
Absolutely. Well, listen, you're at the Law&Crime Network, gavel to gavel coverage. I'm here with Linda Kenney Baden, and on the other end of this break, we're going to come back with some more fascinating analysis from my Jersey girl. Hi, Bob Bianchi, Law&Crime Network. I'm here with Linda Kenney Baden. We've had a great, look, I love when we have an opportunity to discuss after a verdict comes down and in between a penalty phase. I think it's fascinating to talk about all the nuances.
Right.
And there has been some,
in penalty work.
especially death penalty litigation is really intense, really deep. The public defenders usually handle it, and our experts really good at it.
That's right. And you know, I mean, it takes a special kind of person to do that, and that's all they do day in and day out. These death penalty groups and also the death penalty units in the public defender's office. It's a really special person. You may disagree with the criminal defense lawyers, but to do this, it's really very difficult.
Right. Well, we're talking about how much of the witness's testimony will bleed into the penalty phase from the guilt phase, and one of those individuals was Mike Pickens. You may remember him. He was the best friend that afterwards, when the defendant found the sex toys and then took them away, was discussing that with him.
Right.
So we're going to take a look at his testimony, because I think that testimony is also going to inure negatively towards the defendant in the penalty phase, and I'll explain why on the other end. Well, Linda, you know, this is Mike Pickens, one of his besties. Unlike us, they're not committing crimes like this, but he's talking about this issue the night before, the sex toys and the anger, and I think that's something the prosecutor will do with this, is to show that this wasn't just an explosive thing like you find your wife in the bed and you don't have a time to react, if you will. That this was seething and stewing, yes, that's what caused him to do this horrible thing, but he could have had every ample opportunity to stop his thought process. What do you think?
Right, that's exactly right. The classic situation for a manslaughter case, which is when your emotions take over, that used to be taught, and it's kind of sexist, but the husband comes home, finds his wife in bed with somebody, and then shoots the person, right? Goes out to the car, grabs a gun, and shoots the person. He had plenty of time to think about it. He talked to his friend, then he talked to his father the next day. He had the court intervening. Yes, was it anger? Was it seething? Was it probably, you know, he didn't plan it the day before that. He planned it that day. I'm going to get her. But that comes into the category more of a premeditated, intentional murder than it does a, you know, off the cuff, my emotions made me do it.
Yeah, and I think that when you look at all the avenues that he had, people he could have spoken to, including his father, including his friend, including all these people, he didn't have to do this, is going to resonate in the jurors' minds. But listen, you're a Law&Crime Network, and we've been breaking down the James Colley case, convicted across the board of all offenses. He is facing the death penalty, and it's very likely he's going to get it. And we're going to come back on the other end of the break and talk some more fascinating Linda Kenney Baden. All right, welcome back to the Law&Crime Network. My time with my bestie from Jersey, Linda Kenney Baden, is coming quickly to an end, and I hate leaving this chair.
I mean, I could talk with you all day about crime and law and murder and justice and innocence.
Isn't it sick that we would actually enjoy getting off here and going out and having a drink to talk about more crime, more murder, more mayhem? And that's why you got to love the Law and Crime Network, because you get murder and mayhem every single day. Dan Abrams production. Please tell your friends. Get out there and support this network, because it brings great guests like Linda here.
Well, it brings great trials and real people into your living room.
You know, listen, my boss always used to say when I first became a baby prosecutor that you were on the front row of human nature. You see the good, the bad, and ugly of it all. It's really true. And even though it's tragic many times, it's very empowering to see these things. But we're in the penalty phase here, and we just got done listening to Mike Pickens, who had testified in the guilt phase. And there was a lot of bad stuff that was going on prior to this murder, which there was plenty of opportunity to be to cool off, as they would say. And some of that also has to do with some pretty nasty and surly text messages that occurred not only before, but when he went to court afterwards, him reaching out. So, you know, Linda, you see a lot of bad stuff here.
You know, Bob, we always say in our profession that the biggest risk factor for getting murdered is love and marriage. Yeah. Right? And it's amazing how such love can turn to such hate and such violence, and it does.
Yeah, as prosecutor and the folks here on the Law and Crime Network that always support us in our chat room know that I used to say as prosecutor, today's domestic violence is tomorrow's homicide, so be very, very careful about these orders of protection. And even though it's just a paper, there are other things that you can do to protect yourself and target harden yourself. And we used to really try to get out there in the community, especially with the women, and explain to them how they can do that so that tragic things like this don't happen. Nevertheless, we had a detective, David Gauci, in this case, who brought out some of this text message evidence that I think is going to be pretty significant in the jurors' minds in the penalty phase as to whether this was a passion, if you will, thing that he had no ability to deliberate, or whether this was a calm, cool, calculated, premeditated, directed act which will get him death. My last time to say welcome back, at least for today, on the Law and Crime Network, a Dan Abrams production, gavel-to-gavel coverage. Hey, guys, we really appreciate your support. We'd ask you share with your friends. As always, if you ever want to get in touch with me, it's at rbianchi, Bianchiesq. Would love to have you follow me on Twitter and on Instagram, and on Bianchi Law Talk on Facebook. I had Linda Kenney Baden with me all day long. Yeah, and with all seriousness, I mean, I know you are my Jersey girl, and you are one of my besties here on, but you are an excellent guest, Linda. I think you provided our viewers with a tremendous amount of information. And while we're on kind of different sides of the philosophical perspective, more prosecution, more defense, I think we agree on more than we don't. But I love your trial perspective. So thank you so much from the bottom of my heart for being here again. I will be back at the Law and Crime Network on Monday of next week from 3 to 5 and 12 to 3 next Wednesday. Have a great week until I have an opportunity to be blessed to be with you again. Thank you.